Hello students, so now I am going to discuss question number 12 which has been asked in GS paper 2 mains 2023. Now in this question it is talking about the gender justice and asking you to write about the constitutional protections for the women and also substantiate your answer with the relevant case law. Now if you will see that whenever we are writing the introduction, then the major problem that we face in how to introduce it. So as I have discussed earlier also, that what you can do, that whether you can use the definitional based introduction or you can use contextual based introduction or you can use historical based introduction or you can use the constitutional based introduction. These are the four ways of introducing the question in GS paper 2. Now in this question, I know that this question is very easy, but the difficult part is to introduce the question. So I think that it will be better to introduce it from the historical context. For example, if I say that the Indian constitutional makers were aware about the discriminatory attitude or the discriminatory practices in the Indian society, and therefore looking into the discrimination in the society, they have taken an extra care, and this extra care is revealed in the different provisions of the constitution. So just by combining the idea behind these three keywords, I will introduce this question. And then whenever I am talking about the constitutional provision, then or the constitutional safeguards you can say, then I will try to divide my answer as social safeguards, political safeguards and economic safeguards. So under the economic safeguards, if you will see, then one of the article that we can use from fundamental right is 16 clause 2, and 16 clause 2 is talking about that there should not be any discrimination in the matter of public employment on the basis of sex. Likewise, if you will see article 39D, then it is talking about equal pay for the equal work. Then article 41, that is right to work, which will be applicable on the man and the women equally. Now coming to the political safeguards. So under the head of political safeguards, we can mention article 243D that talks about the reservation, that is 1/3 reservation for the women at all the levels of panchayat and also at the level of chairperson at all the three tiers of the panchayat. Now, under the social safeguards, we can safely mention 15 clause 3. We can safely mention 15 clause 3. Here we can mention article 17 and article 23. Yes, article 17 is not exclusively for women. It is for the practice of untouchability. But yes, it is applicable on the women also. So now under article 15 clause 3, we can mention about that a state can make the special provision for the women. And this will be considered as an exception to 15 clause 1. Article 23 is talking about the prohibition on the trafficking, beggar and the forced labor. So these are the safeguards that you can mention. Now the question is talking about the case law. So now in the matter of the case law, you can simply mention here the first one, that is Visakha guidelines. That is Visakha guidelines. And we know that Visakha guidelines have been the bedrock or have been the central point for having the POS Act. That is the prevention of sexual harassment at the workplace. Then we can talk about, we can talk about Lakshmi case, Lakshmi versus Union of India. In this case, we have observed that the acids have become one of the medium for attacking on the women. And then the sale of acids has been or is to be regulated by the state. This has been an understanding of the Supreme Court in this case. Later on, you can mention about the Vinita Sharma case. In this case, you can simply mention that the daughters were considered as the co-parents. In the daughters are the co-parents in the property, in the parental property, no matter whether they have been born before or after the amendment in the Hindu Succession Act 1956. So after mentioning all these, basically you have addressed all the different parts of the question. Now the question arises that how to conclude such simple question. Again, you will face problem in conclusion. So what you can do, that only constitutional protection is not going to introduce or is not going to achieve the idea of gender justice or gender empowerment, because at the same time what we need is gender sensitization. What we need to break down the patriarchal structure. So now what you can do, that in the conclusion you can provide a larger perspective to this question, that how the gender justice can be achieved in the state. Obviously, it is not the job of only a state to go for the gender justice or to think about the gender justice. It's also about our own responsibilities, that being the member of the society, what are our responsibilities. And yes, state can help in the gender sensitization programs, holding conferences, holding seminars about the gender laws, and also at the same time we need to make people aware about the idea of the gender justice. So in this way we can conclude this answer, and I hope that this will be an enough content or enough way of restructuring this particular question. So thanks to all of you.